Good day, Crime Talk aficionados. This is Scott Reisch, and thanks for watching Crime Talk. Now, I hope you all had a great weekend. If you haven't done so already, I'd ask if you hit that subscribe button, hit the little bell so that you receive notifications of when we go live or put up new content. And as always, leave us a comment. Now, first on the docket, a follow-up on that guy named Chris. Now, there's been a lot of new interest in that guy named Chris. Why, you say? Well, the reason is because the Netflix series American Murder, The Family Next Door has been on Netflix, and it is now one of the more popular documentaries that is appearing on Netflix. And obviously people are disturbed by this particular story, and they're doing research on it, and a lot of them are coming here. Now, obviously some people had to wait for Netflix to get this information. All they had to do was go to our playlist, and you could have seen all of the information because there was a lot of information that was left out, particularly as it related to Nicole Kessinger, as we have all those videos in our play section. We also brought you the information last week, and we'll try to be there in court on Thursday when Miss Nicole Kessinger tries to obtain a name change as well. Now, the questions that I have been receiving in the comment section, and not just a few, but a lot of questions, is do you think that Chris Watts actually has a chance of getting a new trial? I have said no chance in that whatsoever. Let me now explain why that's not going to happen. Now, Chris Watts, and I know I probably shouldn't say his last name because the YouTube censors go off, and I'm not sure why we have to deal with that, but it's a reality because a lot of people don't want that name used and certainly don't think that anyone should have a video monetized if they use that name, but we're going to use it and see what happens. So Chris Watts pled guilty for the death of his wife, Shanann, and his two little girls and unborn child. First-degree murder carries a life sentence without the possibility of parole. And before the court sentences anyone regarding those separate cases whereupon Chris Watts received his lengthy multiple life sentences in this particular case, the court first engaged in a colloquy, and they do this on the record. It's called a Rule 11 advisement. The judge goes through and explains in almost painstaking detail. It almost sounds like the judge is trying to talk somebody out of pleading guilty. Why do judges do that? They do that to make sure that this is what the defendant wants to do. That's why all this is done on the record, why it's recorded at a minimum, or there's a stenographer taking something down. The court will not take someone's guilty plea if the court has any doubt to think that this is not a knowing, voluntary plea on behalf of the defendant. He can't be forced, he can't be threatened, he can't have some sort of side agreement off to the side. So the court went through that with Chris Watts. The court would not have accepted the plea if the court was not satisfied. And one of the questions is that the defendant is asked, are you satisfied with your attorney's advice and representation? And that's really kind of a speak now or forever hold your peace moment. Why? Because there's post-conviction relief matters that we'll talk about in just a second that come in. And in this particular case, Chris Watts said he liked his attorneys. They've been great. They've talked to him about everything. All right, that's it. Chris Watts comes back. They have sentencing. He goes to prison for the rest of his life. Never going to get out. Now, there are time restrictions on 35C. 35C is the criminal rule of procedure in most jurisdictions as it relates to post-conviction relief. Post-conviction relief is when somebody says, my conviction was obtained unconstitutionally. Those are very difficult to prove, particularly when there is, in fact, a guilty plea. All right? With a guilty plea, you admit as a matter of law and as a matter of fact, you did what you pled guilty to. All right? Think about it. If you go in for a simple speeding ticket, and instead of a speeding ticket, you get a defective headlamp, what is always going to be on your driving record? It's going to be defective headlamp. You made it up for plea negotiation purposes, but it's always there. And from there on out, you'll always have those points and it'll be reflected for you. As a matter of law and as a matter of fact, that's what took place. It doesn't really matter. Here, Chris Watts pled guilty to the death of Shanann, his 2 little girls, as well as his unborn child. After deliberation charges, those have an unlimited amount of time. There's no time limit in which to file a 35C. On the charges, for example, relating to the death of the unborn child, Nico, there's a 3-year time bar. So after 3 years from the date that you're sentenced, you have 3 years in which to file a post-conviction relief motion. Now, here's the thing. You only get one bite at this apple, because if you file your motion and it's denied, your only remedy then is to appeal to the district court and say, hey, this is what the district court received from me, saying why I received ineffective assistance of counsel. Please appoint me an attorney. Trial court looks at it, denies it. At that point, they can only appeal to the Court of Appeals. Court of Appeals will look at it and say, yeah, not sufficient basis, or reverse and remand and tell the court to give him an attorney if he doesn't already have an attorney. But what do you have to show? You have to show that the standard of care for that attorney, their ability to represent, fell below the standard of a reasonable attorney basically in the same situation. No one's going to say that these attorneys' standard of care fell below that of a reasonable attorney. And I can guarantee you, mark my words, they have documented with painstaking detail that they went and spoke with Chris Watts and said, here's the offer. What do you want to do? Hey, plead guilty. Let's just get this over with. Anytime you're having a client go to prison for the rest of their life, you're going to document and make sure that they understand everything, and you're going to go over everything. And you're going to weigh the options, saying, hey, you got the death penalty, but no one's got it in Colorado in a long time. And right now it's not even there. So why would you plead guilty unless it's the client's decision? Understand, it's always the client's decision. No attorney can tell someone to go plead guilty. In fact, one of the questions that the court asks in the colloquy is anyone forcing you to do this? Are you doing this of your own free will? Chris Watts said, yes, he in fact is doing this of his own free will. The next step would be you would have to show that the standard of care from their attorneys fell below a certain level standard, and then you'd have to show that something has changed, that something was done or not done that would have resulted in a substantial likelihood of a different verdict. And I say the verdict because most 35Cs are done after trial. They're done after trial because most people go to trial, they proclaim their innocence, they do the appeal process, and then the 35C process begins 3 years from the date of the final conviction on the appellate process. Well, Chris Watts didn't appeal anything because there was nothing to appeal at that time. Now, there's been talk, and we have a recording of Chris Watts apparently saying that he was somehow taken advantage of during his interrogation. Well, guess what? He wasn't taken advantage of. He went to the police station on his own. His father was there with him. He knew that he was not under arrest. He could have left at any time, and he voluntarily engaged with and agreed to talk to the detectives as well as engage in a polygraph examination. We have all those videos. You can see for yourself. What Chris Watts would try to argue would simply be the fact that he was somehow manipulated into talking, which he otherwise wouldn't want to have done. The reality of it is he failed the polygraph test, and then they said, why don't you tell us what's going on? And he crumbled. And in fact, on top of that, we know that he then lied about stating that Shanann had done something to the children, and it was some sort of revenge killing on that part. We know that from his interviews where the police and FBI agents, CBI agents, go up to his prison and talk to him, and he basically says, I never would have thought of that but for the agent telling me that as a possibility. Now, the agent's going to say that that was simply something that was done to get him to talk. And guess what? It did. And ultimately, he confessed. So, to wrap things up once and for all, is Chris Watts going to file a motion for post-conviction relief? Probably. What else does he have to do? What does he have to lose? Do I believe that it will be denied? Absolutely. Will he then attempt to appeal that denial of the post-conviction relief? Yes, he will. And I think that it will be denied. There's nothing in the record thus far other than him saying, now basically I have some buyer's remorse, and geez, I've been here, a couple of years now, and this is really just not that much fun. And, even getting a divorce and paying a lot in maintenance and child support would have been a lot better than what I'm facing right now. The reality of it is he is staying in prison. He's not going anywhere. I hope that answers anyone's fears that he could possibly get a new trial. Simply not going to happen. Another delay in the Chad Daybell matter. As you may recall, the motions hearing in the Chad Daybell matter was set for October 29th. That was the motion on the motion to dismiss filed by Chad Daybell's attorney, Mr. John Pryor. I actually thought that we would probably go to this particular hearing since Mr. Pryor's actually been the one who seems to require the least amount of adult supervision when he is in court. The basis for the motion is that the parties had just received the transcript from the preliminary hearing, and that needs to be reviewed and prepare legal arguments and draft their motion. Now, certainly they had their notes. They can certainly go watch it here on Crime Talk because we put the entire preliminary hearing up. So now I guess he just needs the transcript to make references to the court for any appellate record. Needless to say, the court has granted the stipulated motion, and the new hearing date for Chad Daybell is now November 24th, 2020 at 9 a.m. Please join us because we'll be there for sure. Lori Vallow's attorney is tweeting. That's right, and you're not going to believe what he's saying. Mark Means, the attorney for Lori Vallow, has made a couple of tweets today. The first one has a little gif of little mice running away, and it says, "As I prepare the defense for Lori Vallow, I am learning that persons like Melanie Gibbs and her boyfriend, David Warwick, appear to have been eagerly involved in more than they let on. If you know of something, say something." So apparently he's conducting his investigation in this particular case on Twitter. Then he also tweets at the same time, which I think is the most significant one, "The defense lacks the resources of the prosecution," referring specifically to the state of Idaho, the Attorney General's office, the FBI, the Chandler Police Department, the Madison County Sheriff's Department, the Fremont County Sheriff's Department, and don't forget the Rexburg Police. We need the persons of knowledge to come forward. Well, ladies and gentlemen, what do you think that means? It could mean a couple of things. Well, first, I don't think I would be out there tweeting about my case, particularly telling the world that you don't have the resources. Yes, you will never have, nor will any defendant ever have the resources that the state has. But actually asking, we need the persons of knowledge to come forward. What the hell does that mean? Does it mean there's some sort of witness out there that knows all, that knows exactly what happened to JJ and Tylee? Or is he saying, man, I need as much help as I can get because there's a bunch of stuff I have neither the time, the energy, nor the resources to go through, which would possibly include all of the data that has been provided by the FBI. Needless to say, you don't want to show your cards. The "oh, woe is me" defense has never worked in a court of law as far as I can recall, because every defendant would do that. If he does not have the resources to properly conduct an investigation in this particular case, Mr. Means should withdraw and allow the Office of the Public Defender to take over so that she can receive an adequate defense. And so, therefore, if there is a trial and a conviction, the first issue raised in post-conviction relief matters will not be ineffective assistance of counsel. It's about doing the right thing for your client. It's not about getting your 15 minutes of fame. We'll see how that case continues to go about, but that is certainly not an investigation. Please help. Please, if you know something, we don't have the resources. No one ever has the resources to go up against the government. That's why it says the people of the state of Idaho, versus Lori Vallow. And that means all the resources that come with the state. But you still have to be able to mount a defense. And if you don't have the resources to hire an investigator, that's when it's time to get off the case. Next on the docket, Derek Chauvin. Remember that guy? Seemed to cause a lot of trouble around the United States. Well, guess what? A judge has dropped the third-degree murder charge against him in the George Floyd matter. That's right. A judge has dropped the third-degree murder charge against former Minneapolis police officer Derek Chauvin in regards to the death of George Floyd. Now, Chauvin still faces charges of a second-degree murder and second-degree manslaughter, and obviously this sparked a whole lot of protests and a lot of discussions over race and policing this summer. Now, Chauvin, who was released a couple of weeks ago on a $1 million bond, was seen, obviously, in the video that started the whole thing, putting his knee on Mr. Floyd's neck. Now, the dismissal of the charge has been stayed, which means it doesn't go into effect for at least 5 days. And what that does is it gives the prosecutor an opportunity to decide if they want to appeal to a higher court. Now, the judge agreed with Chauvin's defense team that the third-degree murder, that it did not apply in this particular case. The judge said prosecutors were only able to prove 2 of the 3 elements required for the charge. What have we talked about a lot here in Crime Talk? They have to prove each and every element beyond a reasonable doubt. They have to present some evidence related to the charge to make it get beyond challenges in the early pretrial proceedings. Those elements that they were only able to show was that Floyd died and that Chauvin caused his death. But the final element of probable cause for third-degree murder involves proving that the defendant was putting people other than the victim at risk. So it was an unusual charge, and that's why the court agreed with it. The defense gets a small victory, but it really doesn't matter because court reasoned that Chauvin's actions were directed only at Floyd, and they did not and could not have resulted in harm to anyone else other than Floyd, so therefore probable cause didn't exist as to the third-degree murder charge. Normally, that charge would be used in a better situation where, for example, someone were to randomly shoot into a moving train and somebody was killed. It's kind of an extreme indifference. And here, the actions were directly focused on George Floyd, not some third party. We'll see how things go. Maybe that's the start of good news for Mr. Chauvin, or maybe an insignificant victory for sure. We'll have to wait and see. Like I've said before, ultimately, this case is going to be decided by a jury unless Mr. Chauvin and his fellow officers or former officers decide to take a guilty plea. Chad DeBell's counsel filed a motion basically giving the court some additional authority that he must have found during his research that supports the notion or the proposition as to why he should have a separate trial from Lori Vallow. As you may recall, Chad and Lori Vallow are both charged with the same and similar charges relating to the delay and hindrance of the deaths of Lori Vallow's children, JJ as well as Ty Lee. Now, Lori Vallow, and through her attorney, has said, hey, we want a joint trial with Chad DeBell. Chad DeBell, through his attorney, has said, oh, hell no, we're not doing that. And he has filed an objection to any severance whatsoever. Motions are coming up, and although the court's not granting access to any motions that have been filed, the court has granted or posted the notice of submission of authority. Now, oftentimes when you file a brief, sometimes there's a new case that comes out and you file supplemental authority. In this particular case, Mr. Pryor, on behalf of Chad DeBell, cites the case of State v. Nava. And what the case of State v. Nava discusses is what is the correct legal standard for a motion for severance and or joinder. Joinder, bringing the cases together. Severance, separating them so that you can have separate trials. Now, in this particular case, this was regarding separate allegations and whether it should be allowed in under 404B evidence, so we've talked about many times here, which is evidence of other crimes and misconduct. And so this opinion of People v. Nava was issued by the Court of Appeals, which the district court has to follow. It gives them guidance. Now, it's not exactly the same facts. and it's not exactly the same scenario in Nava, but the law is what it is cited for. And the general proposition is that it's an abuse of discretion standard, which means that it won't be looked at by the appellate courts unless they think that the judge just abused his discretion whatsoever. If there wasn't some basis in fact and law to either grant or deny a severance. And that's what happened in the Nava case, because the court said you shouldn't have allowed in testimony that wouldn't be admissible against the defendant unless you brought in this separate charges. That's exactly what's going to take place here. There's going to be evidence in, let's say, for example, Chad Daybell and Lori Vallow have a joint trial. There will be some evidence that will be admissible only as it relates to Lori Vallow, and some evidence admissible only as it relates to Chad Daybell. Chad Daybell is clearly thinking, at least his attorney is thinking, and I think Mr. Pryor gets it. This guy seemed very comfortable in the courtroom, and I'm telling you, as an attorney for 25 years, done criminal defense work. Of the two attorneys in this particular case for Lori Vallow and Chad Daybell, Mr. Pryor is the adult in the room. He clearly has trial experience, and he knows what he's doing. He's setting up air just in case he loses on this motion for severance. Bottom line is there's going to be a lot of information that's going to come in as it relates to Lori Vallow and her conversations with other friends and individuals. Now, Chad Daybell wants that information to stay out because it wouldn't come in at his trial because he just doesn't think that it's relevant. And remember, what is relevant evidence? Evidence that goes to prove or disprove a material element in the case, right? The element, did they do something that resulted in the delay or hindrance or the discovery of JJ and Ty Lee? If it doesn't go to prove those elements in the charge, it's not relevant. We're not going to have a circus. We're not going to have a sideshow. There may be lots of other things that the prosecution may want to introduce that will have no relevance as it relates to Chad Daybell. If that testimony were to come in, it could be prejudicial. Probably would not be able to be cured by a limiting instruction that the court would give to the jury and say, you're going to hear some evidence in just a second, but you can only use it as it relates to one defendant, not both. And in that particular situation, the court should probably err on the side of separate trials. Now, wouldn't it be easier if they just did one trial? Absolutely. And in this particular case, there's a lot of evidence that is absolutely identical. The only one that helps, though, is probably the prosecution because they get a dry run at this particular case. Clearly, as I've stated before, Lori Vallow's attorney is in over his head, as you may have seen from our previous show the other day. Mark Means, Lori Vallow's attorney, is putting up gifs basically saying that all of the witnesses in the case are little rats running away. I think I said mice, but thankfully somebody corrected me. Those are little rats. And that the people with the knowledge, although it's unclear, is this expert witness testimony to somebody that knows something out there, that they need to come forward and they need to help. They need the resources because they lack resources, which clearly shows, at least in my mind, based on my experience, this guy is desperate. If he's putting out tweets to help the investigation because he doesn't have the resources either for himself or to be able to go out and hire an investigator to go investigate and talk to all these potential witnesses. It takes time and it takes money. Why? People don't work for free, ladies and gentlemen. They don't. Somehow everyone thinks lawyers should work for free or pro bono. When was the last time you were able to go to the grocery store and say, I'm going to take these groceries and I'll pay for them next week? Or I'm going to go get my car fixed and I'll pay you later. It doesn't work that way. But as I said the other day, Mark Means should probably file a motion to withdraw if he doesn't have the resources to effectively represent his client. He has a duty to his client, and if he can't investigate it, he should go ask for the court to give him court-appointed money, or second, he needs to withdraw so the public defender could be appointed to Lori Vallow's case. And we're not saying that because we want this case delayed. We're not saying that because we're rooting for Lori Vallow. Not at all. What we want is a fair trial that's not going to come back on appeal because of ineffective assistance of counsel. We'll have to wait and see as it relates to what happens for the motion for severance and or joinder. Obviously, the prosecution wants to join him. Lori Vallow says, yeah, we're on board, because he wants to coattail off of Chad DeBell's attorney, Mr. Pryor, who clearly knows what he's doing, whereas Mr. Means has been struggling all the way. Maybe I'll be surprised, but at this point, not so much impressed, that's for sure. That's all we have for you today. Have a great weekend.